Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. We want to welcome you to this morning's webinar, where we're going to be talking about laws that protect information, one of my favorite subjects. A couple preliminaries before we get started with the actual presentation. First is that this session is being recorded. And if by chance you would want a copy of that recording, in a few days, it'll be a link will be posted to our website on the training tab, and that will take you to our YouTube channel where you can find a copy of this recording. It's available for future reference for yourselves. Perhaps you have a colleague or friend who couldn't make it this morning and they would benefit from it. Or maybe you're having some sort of localized training. You're welcome to use our recording for those purposes. Also, the PowerPoint that's being used, that is available on the website as well, along with all of the PowerPoints that we use for our training. And again, feel free to access that as you need. You can download it. Future reference, colleagues who might not have been able to attend this morning, or your own localized training. It's a public record, so you can have access to it right off of our website. Excuse me. A couple ground rules for the session. If you've never attended one of these before, it's basically the PowerPoint presentation with me talking in the background. On the screen, you'll see that there is a chat feature. So as we're going through the PowerPoint, if you have a question, feel free to type it in, and I'll do my best to answer it as we're proceeding through the presentation. Now, a couple conditions are associated with that, though. First offhand, we're talking about the right to know law and other laws that protect information. So we want to stay on topic, okay? The other thing that I would ask is that try to keep your questions as succinct and honestly as short as possible. Sometimes folks have a habit of typing in several paragraphs, and it's just awkward for me to sit here and have to read through that in silence while everyone else is patiently waiting. If you have something that's unusually complex or perhaps specific to your situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll come back to it and answer it for everybody's benefit. Or I'll suggest that we take the conversation offline. On the screen right now is contact information for the Office of Open Records, the phone number, the website URL. And on the website, there are email addresses, or email accounts specifically for people to write in with their questions. And the administrative staff here at the OOR is very well versed in the law. And if they can't help you out, they'll escalate your question up to one of the senior executives. And someone will usually get back to you within 24 hours because we figure, if you're reaching out to us, chances are it's important and more than likely it's time sensitive. So we want to make sure that we get back to you and get you steered in the right direction. We can't answer requests for you if you're from an agency. We can't write requests for you if you happen to be a requester. And we can't comment on any active appeals or provide legal advice. Now, that's saying a lot, but there's a lot in between that we can help you and, like I said, get you steered in the right direction. Okay, so for the next hour or so, let's talk about laws that protect information. And first offhand, let's cover why is it important to discuss these laws? Well, the right to know law, if you've ever sat through the basic session, you'll hear me say that it's not a confidentiality law. Essentially, the right to know law identifies records that an agency can withhold from public disclosure if those records fall within the definitions outlined in the exemptions in Section 708B. Now, an exemption is just that. It's basically a definition of a type of record that can be withheld from public disclosure. But there are other laws, which we're going to be talking about here this morning, that do not afford an agency that discretion. Rather, it's mandatory that these particular records cannot be released into the public domain. So it's important for an agency to know what those other laws are. And this is referred to in Section 306 of the Right to Know law, where I'm paraphrasing here, but basically it says nothing in this act shall supersede or modify the public or non-public nature of a record or document established by federal or state law, regulation, or a judge's order. Okay, so essentially translating that to English is that if there is another law that says this particular record is confidential, then that law trumps any discretion afforded to an agency in the Right to Know law. It basically says, no, you cannot release this record, even though the Right to Know law says you may release this record. Okay, Right to Know law gets superseded by the other law. So it's important that we know what those laws are. Now, how do we identify them? Well, it's basically through experience. When we came up with this webinar, we took a look at our own history of final determinations and focused in on the most common laws that are referenced by agencies when denying right to know requests without particularly using the right to know law itself as their legal basis for doing so. The other thing is we relied on suggestions from our customers. It's like, what laws do you frequently encounter that you feel would be helpful for everyone to know about? So today, I think we're going to focus on about 12 laws. And, I apologize, there's not a lot of continuity. We bounce around a lot, but that's the nature of what we're looking at with right to know requests, because, as you can probably guess, right to know requests are all over the map too. People want to know virtually every aspect of what their governments and government officials are up to. So our experience has been that there's a fairly broad spectrum of laws that are referred to by agencies, which brings us to the second point. If you've ever attended the Basics of the Right to Know law course or webinar, you know that it is the agency that bears the burden of proof, that if they're going to withhold a document from a requester, they have to make their legal case as to why they believe it's appropriate to do so. Now, typically, an agency will refer to one of those 30 exemptions in the right to know law that I was talking about. But let's say that there is a record that may not be covered by the right to know law, but is covered by another law or potentially a judge's order. Well, in meeting their burden of proof, they would in turn refer to the appropriate confidentiality provisions of that law in order to meet their legal burden. Okay, and I'll give you a quick example here. Let's say that there is a police department, and that police department maintains a file on suspected gang activity within their jurisdiction. Okay, it's what we call criminal intelligence information. Okay, it's not necessarily keeping track of any criminal activity per se or any crimes committed, but rather is just information on things we've observed, things we've heard, things members of the public have come to us about regarding suspected gang activity within the township or city or borough or whatever. All right. And they keep that file available for reference by officers within the department. Well, if you take a look at the right to know law, specifically, I would go to Section 708B16. It deals with criminal investigatory files. But there's no mention in the right to know law of criminal intelligence files, which is what we're talking about here, because they're not referring to any specific crime or court case that has been committed. Well, there is another law in Pennsylvania that we're going to refer to here shortly called the Criminal History Records Information Act, CRIA. CRIA does specifically reference criminal intelligence information. So what if somebody submits a right to know request to the police department for a copy of that file? They're not going to be able to deny it based on any language in the right to know law because it's not there. But if they refer to CREA, two things. One, it is there. Okay, there's a reference in CREA to criminal intelligence information. Two, CREA removes any discretion that the right to know law would provide in the agency being able to release that information. CREA doesn't say you can withhold this if you want. CREA says you must withhold this, and you can only share this information with other certified police departments as defined by CREA. And I'll explain why I just said that too. Okay, but you see how this burden of proof aspect is important when it comes to being aware of the language in other laws, because not only does CREA say you can't release it, there happen to be sanctions built into CREA that the police department, potentially could face criminal sanctions. And while there's not a lot of activity there, we have seen it. Okay, so this is just one example of a law that protects information that certainly anyone involved in law enforcement needs to be aware of. Okay, so let's talk about CREA directly, the Criminal History Records Information Act of 1980. Now, who does CREA apply to? Well, any person or agency that collects criminal history information, such as police departments, prisons, district attorneys, sheriffs, and the courts. Now, when it comes to police departments, I want to emphasize that CREA has its own definition of a police department, of a law enforcement agency per se. Okay, and that's important because there are other laws that also define law enforcement agencies. Those definitions in the other laws do not apply to CREA. CREA defines itself. And again, if you've ever participated in one of these webinars, I tell people that when you truly want to understand how a law works, don't forget to read the definition section. And just a quick example, we're going to be talking about actually, we're not going to be talking about, but there is another law called Act 22 that governs access to video records recorded by law enforcement agencies. Under Act 22, a law enforcement agency is defined as any entity that employs a licensed law enforcement officer. Okay, and our experience has shown that under that definition, it could be school districts, it could be a railroad, it could be any number of other entities that employ a police officer. Okay, to say that a school district is a law enforcement agency is kind of a stretch, and we've expressed our dismay over that in some of the decisions that we've issued, hoping that at some point the legislature will come back and perhaps correct that or clarify that language. But it shows that, a law enforcement agency as defined by Act 22 would not necessarily qualify as a law enforcement agency as defined by CREA. So it's important to make that distinction. And then CREA, in essence, protects any criminal history, investigative, or intelligence information that are in the possession of those law enforcement agencies as defined by CREA. Thus, that information can only be shared with other applicable law enforcement agencies. They can't release it to the public, the news media. There was even a case where the Office of Open Records attempted to get information that was in question and being denied by a law enforcement agency under the provisions of CREA. And the court said, no, Office of Open Records, you're not a law enforcement agency. Therefore, you can't have those records. And, in essence, it was a test. And ultimately, we complied with that. We agreed with it, and we embraced the court's decision because of the literal application of that language in CREA. Now, if you're here from a law enforcement agency, or perhaps you're looking for records that may be in the possession of a law enforcement agency and you've come up against this law, there is a very good resource on the Pennsylvania Attorney General's website. It's the CREA Handbook, and you want to take a look at that. I strongly recommend it. The Pennsylvania Attorney General's office is what we'll call the point agency on the administration and application of CREA. If you have further questions, reach out to them, and they've proven very helpful in the at least in the inquiries that I've made and discussions that I've made or had with the Pennsylvania Attorney General's office. Good resource. Okay, another law enforcement related statute that we need to be aware of is Act 30 of 2016. This applies to public safety answering points, or what they also define as emergency call centers, what we commonly know as 911 centers. Okay, 911 centers are prohibited from giving out individual identification information of anyone who calls in, anyone who is identified as a witness or a victim of, potential crime. Rather, in defining that personal identification information, it's like the person's name, any telephone numbers that the call may have been made from, and of course, any home addresses. There is this in Pennsylvania, what's referred to as the constitutional right to privacy. Okay, and clearly the courts have said names, phone numbers, home addresses are not public information in the majority of cases. Rather, that's protected. You don't give those out. So 911 centers are very cognizant of this, and thus they've developed practices that protect this information. Okay, now, Act 30 does not protect the location of an address unless it would compromise any of this individual identification information. So what they've ended up doing is, if you listen to or if you see any reports coming out of a 911 center, even what they give to the media, rather than saying there's a fire at 333 Market Street in Harrisburg, they'll say there was a report of a fire at 3rd and Market Streets in Harrisburg, or actually, looking at where we're at here, it's closer to 4th and Market in Harrisburg. So they'll say that, or the 300 block of Market Street, rather than give the actual building address. And they'll do that, for any incident that has been reported and subsequently dispatched through the 911 center. Okay, and then, like I said, using my example, you end up with block numbers, cross streets. If it's out on the interstate, they'll give a mile marker. Okay. Oh, I had a thought here and it just left my head. Oh, well, it must not have been that important. Oh, yeah, I know what it is. I use the term 911 centers, but this also applies to those law enforcement agencies that may have localized dispatching. So, for instance, there may be a police department that when you dial 911, like during daytime hours, the call goes directly to the police department rather than the county call center, because it's usually how that's set up. The 911 centers are administered by the counties. It still applies. They are still defined as public safety answering points, which is why we have that mouthful of a phrase there. Just so everyone understands, it's not 911 centers exclusively, that if you have a local law enforcement agency that receives the 911 call, they are considered a public safety answering point. Thus, Act 30 applies to them as well in limiting the information that they can give out about the call. So looking at this from the requester's perspective, if you happen to be joining us today and you're a requester, a potential requester, if you submit a right to know request to a 911 center for information regarding a call, usually my experience has been someone will submit a request because someone called the 911 center complaining about them, you're not going to get most of the information that you're looking for, because not only does the right to know law protect it, but Act 30 also protects it as well. Okay, bouncing around a little bit, attorney-client privilege and work product. Okay, now this applies to solicitors and their client agencies. But what is attorney-client privilege? Well, any sensitive information that is imparted by an attorney to his client, between the lawyer and the client, that involves legal advice and strategy, is protected under attorney-client privilege. And, for our purposes here, dealing with the right to know law, we're talking about agencies and their solicitors or chief counsels, okay? Any emails, reports, memos, and the like, where if we were to look at it, you can discern legal strategy and advice, that's protected, okay? And it cannot be released. In Pennsylvania, attorney-client privilege is considered to be part of the rules of evidence, which is, statute. Now, let's say, though, that an attorney, a solicitor, provides an email to a borough council, and one of those councilmen or council persons goes rogue and releases that email to a couple friends. Well, at that point, privilege has been broken, and that communication does become public. Now, whatever sanctions the council takes against that particular council person, if any, that's outside of the world of right to know, okay? That's up to the council. There's nothing in the right to know law or attorney-client privilege that discusses sanctions per se for breaking privilege. This usually comes up when we're looking at invoices that solicitors have submitted to the agencies. Typically, we see right to know requests where someone wants to know how much is our township paying the solicitor. Okay, I want to know how much this is costing us. All right, well, chances are that those invoices are public records unless they go into such detail that you can discern legal strategy. Now, if a solicitor just says, for this month, I'm billing you, 12 work hours, all right, that clearly would be considered a public record and could be released in response to the right to know request. However, let's say that the solicitor says, this month I'm billing you for 3 hours for researching case law on this particular legal strategy related to the lawsuit that we're facing from XYZ company. Or I'm billing you for 6 hours that I spent preparing witnesses that we hope that I'm considering having appearing in this court case that we're facing next month, okay? If by looking at the details brought forth in the invoice, I can see the strategy that the borough is taking, that their solicitor is taking, there's a good chance that A, we might withhold the entire invoice from release, or we may choose to redact that sensitive information that would otherwise unveil the legal strategy. If it's not clear to you, my recommendation is always go to the solicitor and ask them, do you consider this information to be covered by attorney-client privilege? Let's say they do, and you withhold it. Well, the requester can always appeal, and our appeals officers will sort it out, okay? But when in doubt, I suggest deferring to the opinion of your solicitor, and we'll just take it from there and see how it plays out. Okay, and then all of this is, you can get a clearer picture of attorney-client privilege in the right to know law itself, looking at section 305A2. Okay, that's where the actual reference occurs. Okay, bouncing around once again. This one comes up fairly frequently. It's the Uniform Construction Code, or what's commonly referred to in Pennsylvania as the UCC. It essentially is Pennsylvania's statewide building code. and it applies to any agency that would be in possession of building permit applications, the plans associated with those applications, and really any other associated records. Okay, UCC has a confidentiality provision in it that allows agencies to withhold certain records related to the application of building permits. Okay, so it's actually protecting the application itself, any building plans, specifications, inspection reports, similar documents for buildings constructed after 2004. Okay, what's that all about? Well, the UCC wasn't adopted in Pennsylvania until 2004, and it doesn't grandfather any buildings that would have been approved for construction prior to 2004. So if you're looking for any information pre-2004, the agency would have to take a look at what building code it had in force at that time. And I'm, old enough to remember that back then we had the BOCA code. Some municipalities use the Life Safety Code through the National Fire Protection Association. Some municipalities had their own specific codes for their municipalities. And the problem is it just became a real bear to enforce, having all these different codes that would change once you went over a jurisdiction line. If you were a contractor putting up buildings or a developer, it was a real issue. So Pennsylvania adopted the UCC in 2004. And like I said, if you're looking for records that predate the UCC, the agency would have to take a look at, okay, what building code did we have in force at that time? And really, what version of the code, because they would change from year to year as they were updated. Okay, now the permits themselves that are issued approving construction, they are public records and they are accessible under the right to know law. Okay, now here's an interesting tidbit of information for you. There is a common acceptance among most code enforcement officers that the UCC only applies to commercial construction. Our office disagrees with that. And this goes back all the way to 2012. So we're talking about a decision that has been in force for over 10 years, where we did an analysis based on an appeal that was submitted of the UCC and the language contained in the confidentiality provisions. And we determined that the confidentiality provisions of UCC extend to private dwellings as well as commercial structures, not based specifically on what it says, but rather based on what it doesn't say. Okay, and if you're curious about this, you can find the decision, Ness versus York Township, and the docket numbers on the screen now. Go to our website, take a look, do a docket search on our final determinations. This decision will come up and you'll read the logic that was used by the appeals officer at the time to reach this conclusion. It has never been challenged in over 11 years. So as it stands today, this is the law because our decisions carry the weight of law. Okay, but if you take a step back and look at this, why would you give out any plans for a private dwelling in the first place? Okay, why would someone request it? Chances are they're up to no good, but you would not give out your home plans, okay, through a government agency. So this decision validates that by establishing legal precedent for doing so. Now, if there's a violation of a building code, that becomes a legal issue, okay? And it's kind of outside the right to know law, but because in Pennsylvania court records are public, you would not submit a right to know request to an agency for any citations, but rather because they're court records, you would go to the courts and use their Rule 509 process in order to get access to those public records. Basically, the litigation or criminal activity that may be in place because of a building code violation. And then, I want to make a distinguishment here that we're not talking about zoning hearing boards. Those are, and the confidentiality provisions and access to public records are covered by the municipality's planning code in Pennsylvania. All right, the question has popped up here. Our building permits are actually the application. For example, the resident submits application, bottom of the form is then signed off as approved and becomes the building permit. Can we deny the permit because it's also the application? Okay, Renea, what I would suggest there is perhaps redacting the application the application information, but releasing the record itself where you can see the approval of the permit approval. Okay, and yeah, I'd talk to your solicitor about that, perhaps your building codes person, and the approved permit is a public record. So if there's something on that combined form that represents the approval, I would release that. Just redact the sensitive stuff that's included in the application portion of the form. Okay, good question on that one. I've never encountered that before. Okay, so moving on from UCC, let's get into the alphabet soup of health-related information laws, because these are pretty black and white. It's just that each law covers a different aspect of health-related information, or they come at it from a specific direction. Now, the first one is probably the one that's most commonly known. It's HIPAA, the Health Insurance Portability and Accountability Act of 1996. Again, I'm old enough to have been around when all this came down back in 96. And HIPAA applies to healthcare providers. Okay, it doesn't typically apply to employers. So you ask, well, why does this come up with the right to know law? And it's because there are some agencies that qualify as healthcare providers. For instance, counties may still have senior centers that they run directly or de facto through contract. They'll hire an agency to run what used to be the county senior center. Okay, so they may, because of that, be in possession of health records for clients. Now, HIPAA protects individually identifying that personal health information. It kind of goes back to what we were talking about with Act 30. Anything that reflects the health and the records thereof of a client would be protected by HIPAA, and you cannot give it out. Okay, now, let's say that one of these agencies also, for whatever reason, has employee health-related information. Well, an employee can voluntarily approve the release of that health information to their employer, but then the employer must keep it secure, okay? So, and I'll get into an example of that with another law that we're going to be talking about, but this seems confusing, but you have to understand HIPAA covers a broad range of scenarios. For our purposes, it's an agency acting as a healthcare provider, okay? But we also run across occasionally those instances where there are provisions in HIPAA that also apply to agencies in its role as an employer. Okay, so you've got this arcane clause in there where an employee can say, it's okay to give out my health information, but then there are still obligations upon the agency as the employer to keep that health information secure, only giving it out on a need-to-know basis. And there's another law where this also applies. Which takes us to FMLA, the Family Medical Leave Act. And I think this more closely applies to state and local agencies in their role as employers, specifically HR leave administrators and direct supervisors. Now, FMLA, because of the title, leave, focuses in on any health-related condition that can have an impact on the leave usage of an employee. Now, it also affords employees to take specific types of leave under specific conditions. But as an employer, you need to be concerned about any information that leads up to the approval or disapproval of that leave and the leave usage itself. Okay, you need to be concerned about any of that information that's given out. And when it comes down to it, basically what FMLA says is don't give it out. Okay, now you're thinking, okay, how does this specifically apply to an agency? And how could this relate to the right to know law? Well, let's say you've got a public employee who's home for a couple days. And maybe they're out mowing their grass, and you've got a nosy neighbor who submits a right to know request. I want to see the leave records for this particular employee to make sure that they were approved to take off this day. They weren't just hiding from work or not doing any work that day when they should have been. Let me get a sip of coffee here quick. Okay, so under FMLA, well, think about this. If you happen to be an HR director or a leave administrator, if an employee is off for 3 consecutive days, what happens is that they should be receiving a survey from the HR office asking, was this leave related to a serious health condition? Now, in my example, obviously it was not. But what if you have an employee who's off for 3 days because of a serious health condition? Well, if I were to release that employee's leave records by seeing 3 consecutive days taken off sick, I could be divulging the fact that this employee suffers from a serious health condition, and suddenly I'm in violation of FMLA. And there would be, both civil and potentially criminal violations there. So you can understand why this would be important. Now, again, an employee, or for that matter, the employer, can provide supervisors and medical first aid personnel with information related to that employee's health condition on a need-to-know basis. For instance, if you have an employee who suffers from epileptic seizures, okay, there is a need to know for a supervisor or a first responder to be aware of that, so that if the employee does have a seizure and the first responders are called, the supervisor can inform them, by the way, this employee has it on record that they have previously suffered from epileptic seizures. That gives the first responders, information that they can use in treating the employee suffering from the seizure. Okay, so you see how that all works. Only on a need-to-know basis, though. It's kept very close to the vest. You do not release it in general to the staff or to the public. Okay. And yeah, the record of absence I've already talked about there as to why you would not, or why you would be very careful with any leave-related information that potentially could be released through a right to know request. Okay. Moving on to another one of the alphabet soup of health-related laws is the Americans with Disabilities Act, or ADA. ADA applies to most employers, and it covers a host of provisions, access for people with disabilities, but for our purposes, ADA specifically protects all medical records, and it requires that those medical records are stored separately from any other personnel records, and that they're kept under lock and key, that they are, secure. Now, in a previous career, I was an HR director for a large state agency. And I remember when ADA came down from the feds. Prior to that, as the HR director, I had access to all the personnel files so that I could, look up an employee and see what was going on. Well, once ADA came out, our benefits staff segregated all the health-related medical records, and I couldn't, as the HR director, access them because it was determined I didn't really have a need to know. Okay, I could see everything else that was in the file, but health-related information was kept separate. Okay, and no one but the benefits staff specifically or the employee had access to it. Okay, now let's say though that an information provides, or I'm sorry, that an employee provides medical information voluntarily, but it's the result of a non-medical inquiry. Okay, under ADA, that is legal. Okay, but you're asking, how could this ever happen? Well, I've got a very real life example. Let's say we've got a municipality that everybody's in, one building, and it's a multi-story. And if you're familiar at all, there's a very good chance that this building has a fire marshal appointed. Usually it's a volunteer position, but this is the person responsible for making sure that, the building is safe, and that if there is some sort of emergency, they have an evacuation plan. Usually, prior to coming up with an evacuation plan, they survey the employees to see if there's any special needs. Well, one of our employees had a hip replacement a couple months ago, and they have difficulty walking downstairs, and they're on the 3rd floor. So in the case of a fire alarm, they would not be able to take the stairs, okay, or they would need help taking the stairs. So as part of the building evacuation plan, number one, the employee has divulged the fact that they have, a health condition that requires assistance. Number two, the fire marshal determines that for this particular employee, we're going to shelter them in place in the fire tower, the stairwell. Okay. And then when the fire department arrives, we'll let them know we have an employee on the 3rd floor of the fire tower who needs assistance evacuating. Okay. Because, of the hip replacement. So maybe they'll take, a chair lift or something similar like that along to assist them in evacuating the building. So you see, using that example, you see how this provision of the ADA works. Number one, the employee has voluntarily divulged the information. Number two, the fire marshal is using it for a bona fide reason, and they're only releasing this information on a need-to-know basis. Chances are they've notified the supervisor and maybe a few coworkers or like assistant fire marshals that, look, in the event of an emergency, this employee needs special assistance. We need to be aware of it, and this is why. Okay, so it all works out in the end, but let me see here. Can the fire marshal for the office discuss the employee? Well, yeah, Tracy, like I just said there, potentially with like assistant fire marshals. Maybe there's like a person responsible for that particular work unit. Like out here at the Office of Open Records, we have a person who's been issued, the big red vest, and they run around and make sure all the doors are shut and that everyone, all the offices have been cleared out. And so there would be, chances are that person would be aware of any special needs among the OOR staff because we're on the 16th floor of this building, as well as the building fire marshal and the like. So yeah, it's like I said, it's on a need to know basis where, kind of like common sense rules the day as to who you tell and who you don't tell. But, if the person got a hip replacement, chances are all the coworkers are aware of it anyway, but it usually works its way out. It's you just have to be discreet in who you notify of this employee's health condition. But yeah, another good question there. Okay, moving on. Let's talk about FERPA, which I mentioned earlier. And again, shifting gears here. FERPA applies to public and private schools, okay, both primary, secondary, as well as post-secondary, your colleges. And the Family Educational Rights and Privacy Act specifically protects individual educational records. Examples being report cards, transcripts, records of discipline. Yeah, records of discipline are considered educational records. So you cannot get this through the right to know law. Okay, and well, you're thinking, all right, but what about when school districts publish who made the honor roll this semester? Well, there's a provision within FERPA that allows publishing what's called directory information. And it also applies to sports teams, okay? The high school football team, won the game last night, and this particular student scored 3 touchdowns. Well, that sports information isn't necessarily considered an individual educational record, or if it is, it's also labeled as directory information, which can be published, which is why, like if you Google a specific person and their high school sports accomplishments come up, because there are websites that keep track of this for recruiting purposes. That's how they get away with it, okay, because it's considered directory information. Okay. Now, individual educational records. So if I were to submit a right to know request for all of the grades issued to each student in a class, because I think, my son received an unfair grade, that would be protected, okay? I could not get the individual grades. But if I asked for the aggregated data, that chances are would be public, provided the district has a report of that data. Okay, and usually they do. I mean, you're probably aware of school districts and all of the mandated reports that they have to generate. So any of those reports of aggregated data could be released, except, and this is an important exception, if by looking at the aggregated data, you can slice and dice it down to the point where you can identify specific students. Occasionally, and this has been covered in case law, occasionally you can drill down into the data to the point looking at various demographic information, like ethnic backgrounds and so forth, where you can say, this is Jimmy, and this is the grade that he got, okay, based on, any number of fields within the data set. If you can do that, then there's a potential violation of FERPA, and the district or the releasing authority could withhold certain data elements to prevent you from being able to identify specific students. Now, what about parents that are having an issue with the school district and they want to see their own students' grades, their own child's grades? You cannot get that information through the right to know law, but FERPA does have provisions for parents to be able to see the individual educational records of their own minors or their, guardians. It is somewhat unfortunate when a school district will deny a right to know request and not notify the parent that, oh, by the way, you can get this information through FERPA. We see that, unfortunately, all too often, and shame on the school districts for doing that, okay? Because there clearly is a mechanism for parents to see their own kids' records. Okay, now, what about when we get up to the college level? Well, when it comes to parents, even though the parents are paying the tuition, the student who's 18 years or older must sign a release in order for the parents to see the educational records. What if, however, the student gets into legal trouble and the campus police file an arrest report? Well, that information is not protected by FERPA, okay? That becomes a criminal record and, again, accessible through the court system. Okay, now, what about school videos? And, how does FERPA relate to that when it comes to individual educational records? Unfortunately, I have to say it depends. Okay, this is an evolving area of case law related to the right to know law. where it's just going to depend on a specific set of circumstances as to whether a school video can be released. We have had the courts rule that, for instance, a video taken on a school bus after hours should be released. A video taken in a school from a fixed camera can be released, but the faces of the students must be either blacked out or fuzzed out, whatever you call that, where it's out of focus, okay? And we've had the courts say that, for instance, the video of the front door to the administration building is a public record, okay? It depends. You have to read the specific decisions and see where the court was coming from in determining, what was consistent with FERPA versus what could be released as a public record without impairing the privacy of the students in order to comply with FERPA. A lot of school districts were taking a blanket approach. They were saying, well, anything that we have is an individual educational record, particularly with video, so we're not going to release it. People would appeal that. Our office would weigh in. Occasionally, it would get appealed to the courts. The courts would weigh in. And, we're headed to, I think, a sound body of case law, but we're not there yet. Okay, so if you read the decisions, you'll kind of see the trends as to what qualifies as a public record versus what does not. Okay, but there's no black and white answer that I can give you at this point. Okay, and then obviously any student health records, they're considered part of the individual educational record and would not be accessible through FERPA or really, any of the other alphabet soup of those health-related statutes that we were talking about. Okay, and then quickly, the Pennsylvania School Code kind of mirrors FERPA, but on a level specific to the state. And probably the biggest difference is that, if anything, the Pennsylvania School Code has stronger language in it where any health-related records created pursuant to the school code are considered confidential. And this would apply where you've got like a school nurse or a health assistant, a nursing assistant, who, for instance, they may have records on file of students that are required to take medication during the day. So the nurse's office, whoever's responsible there, will issue and supervise the student taking their medication. So those records that are kept on file clearly are considered confidential based on the school code, as well as any medical specific statutes that may also apply. But the school code is pretty black and white with that one. Okay, changing gears once again. And yeah, changing gears. You see what I did there? The Pennsylvania Motor Vehicle Code. The Department of Transportation and any agency in possession of driver's records. Well, this could be a state or local agency, particularly when it comes to who can operate the vehicles that we own here or lease. Okay, so it protects individual driver's records. Well, a driver's license under the vehicle code is considered an individual's authorization to operate a vehicle. Thus, it's part of the record. So driver's licenses are considered confidential. And you're thinking, well, why would someone want to see that? Well, if you look at right to know requests, periodically someone will, maybe they saw one of the work crew driving a specific piece of equipment where they thought, what, I bet you they're not qualified to operate that thing because of its gross vehicle weight or the specific type of vehicle that it is. So they want to see whether this person is licensed to do so. Under the vehicle code, that license information is considered confidential. You go to section 6114 of the vehicle code and it's all spelled out. And it's also protected if you look at the right to know law itself, section 708B6. Okay, and you're thinking, what about CDLs, commercial driver's license? Yep, here we go. all CDL information is considered confidential, including the drug tests, the results of drug tests, all of that. Now, if you have an employee who's gotten themselves into trouble, let's say they ran a couple red lights, some speeding tickets or whatever, and they've been brought up before a judge, that falls into, again, court records, which in Pennsylvania are public under Pennsylvania common law. You can't get them through the right to know process, but you can get them through the courts, okay, and following their Rule 509 process. All right, but bottom line is driver's license, CDLs, and the like are considered confidential. And the motor vehicle code is how you would make your legal argument for not releasing them. Okay, federal copyright law. This comes up a lot with people requesting building plans, plans for new subdivisions, and the like. And what we'll see is agencies denying access to a record based on a stamp that's on there. Now, a copyright is anyone who's claiming the use of intellectual property when they prepare a record, okay? To put this in layman's terms, basically they're saying that my original thought went into developing what I'm putting on this piece of paper, and I don't want anyone else misusing that original thought and claiming it as their own. So the copyright law protects those authors who are claiming original thought, and we'll see it like on an engineer's drawing or maybe an architect's plan for something. Now, quite frankly, with an engineer, for them to claim original thought, that's a bit of a stretch, because most engineers in the work that they do for municipalities follow what would be considered industry standards for whatever it is they're preparing the plans for. Okay, there is an industry standard as to how you're supposed to configure this stormwater runoff drain, or the curbing for this particular street, or how this particular traffic circle is laid out. Okay, and to apply original thought, chances are they're not. And if they are, they risk liability because they're deviating from the industry standard. So usually engineers are not claiming copyright. Or if there is some claim of copyright, it's the municipality mistaking the engineer's stamp, which says, I am a certified engineer and I'm qualified to produce drawings like this, for a copyright stamp. Usually, now you can claim copyright without affixing a stamp. So occasionally it's implied, but usually you will see a stamp affixed to the copyright, and it's different from the licensure stamp. So municipalities need to be aware of that. Okay, the licensure stamp does not in itself represent copyright. It just represents that, hey, I'm qualified to produce a drawing like this. Architects may be different. Occasionally they will submit building plans where they claim, this is something really special. So I'm affixing my copyright stamp on here to make sure nobody claims it as their own, because this is mine. I want to get paid for any subsequent use of this particular building feature, okay? And we will see that occasionally. Now, under the right to know law, when it comes to copyright, a person can view a copyrighted record, but they cannot have a copy of the copyrighted record. And this all comes down to language in a court case called Ali versus the Philadelphia Housing Finance Authority. Okay, and they lay it out as to what you can and cannot do related to copyright. However, let's say that you're allowing someone to view a copyrighted record. Maybe it's on display, as part of an open board meeting or something like that, and someone pulls out a cell phone camera and snaps a picture. Now, under the copyright law, any litigation actually comes down to the dispute between the person claiming copyright and the person allegedly misusing the copyright. The agency that showed the copyrighted record typically does not bear any liability. All right, but I don't want to create the impression that I'm giving a legal opinion here. I'm just kind of telling you where the law has come down on all this. So, if that should happen, you don't want to panic that suddenly, oh my gosh, we're in violation of copyright. Okay. And the person who's taking the picture, just by taking the picture, you're not in violation. It depends on what you do with that picture and as to whether you're in fact misusing the claim of copyright that could get you into trouble. Okay. But, that's kind of a long-winded explanation. But again, it's surprising how much this comes up in the world of right to know. And I'm going to say probably 3 or 4 times a year, we will get questions from municipalities about, we have a record where an engineer is claiming copyright. What do we do? Okay, so this is where we steer them. All righty, coming up on the end here real quick. Child Protective Services law. Okay, this applies to anyone in the course of their employment who comes in contact with children. Well, what if you're like a township with a township park and you run a kids program for the summer? Okay, well, if you have an employee or volunteers, they have to go through the child line approval process because of their contact with children. All right, so any of that application process in any of the records associated to that, reports, summaries, medical evaluations, file notes, et cetera, are considered private as part of the application. What if one of your volunteers sees some injuries on a kid that leads them to suspect some sort of abuse? Well, under the Child Protective Services law, they are obligated. Okay, it's not at their discretion. They are obligated. They must report any suspected abuse. So any record of that investigation is kept confidential. Okay, the person submitting the report is kept confidential. Any investigation, any conclusions are kept confidential. Now, this can be a tricky situation because, and I've seen this, you get into, a divorce or marriage issues, and you have one spouse who files a report against the other spouse for suspected abuse. Well, that spouse, who is the target of the investigation, then turns around and files a right to know request. I want to see all the records because this is making my life intolerable. I can't see my kids. Okay. Unfortunately, under the right to know law, there's nothing you can do. You cannot release these records because the Child Protective Services law is tight. Okay. And until it all gets sorted out by the lawyers, unfortunately, you're caught between a rock and a hard place. Okay. What is the age of the children as defined in this law? I think it's up to 17, but I am not sure, Tracy. I'd have to actually look at that again to find out. But I think it's 17. Once you reach the age of accountability, you're not covered by this law anymore. But I'm just speculating, in all honesty. You might want to take a look at the Child Protective Services law and define that for yourself. Okay. And then, like I said, for the people who have to get the clearances, all of that applicant information is kept confidential. All righty. And then one of the last ones we have is the Older Adults Protective Services Act. This applies to elder care. And again, dependent on how your municipality is set up and what services you provide, it may apply to you. But if there is an elder care facility, essentially it applies to the employees, the staff, not necessarily volunteers or the public. But if they see something, like if they're making the rounds and maybe it's Meals on Wheels or something like that, and they see something where it appears there's neglect or abuse, they are legally bound to report this. And when we're talking about elders, it's people over 60 who cannot protect themselves, okay, and would be at risk of abuse or neglect. All right. But this one, honestly, it doesn't come up that often, but it's an interesting one that periodically we run across with, like, the Department of Aging or counties that are running programs associated with elder care. All right, and then we have some, I'm sorry, the Disease Prevention and Control Act. This was a big one during COVID, okay? The Department of Health and county health agencies used this act to prevent the release of aggregated data that they were collecting of COVID infections. This, right to know requests were filed. They were appealed to the courts. And the court said, look, if it's aggregated data, it doesn't apply. It can be and should be released. I think the legislature is still taking a look on this, or look at this, to update this law to make sure that it is clearly specified aggregated data can or should be released. But, we'll see where that ends up. Okay. Yeah, and then some miscellaneous provisions that come up quite often. W-2s, tax information, okay? The Internal Revenue Code says W-2s are confidential. So if you receive, and we see this periodically, someone wants to know how much their public officials are being paid, okay, that information is public, but W-2s are not, okay? So if they specifically ask for W-2s, you deny it based on the Internal Revenue Code. Taxpayer Bill of Rights in Pennsylvania makes it a misdemeanor to release any confidential tax information. Okay, so let's say you are a county tax collection bureau. You can't release this information, okay, based on the Pennsylvania Taxpayer Bill of Rights. Then we have something called, it's referred to as LT, the Local Tax Enabling Act. This also protects information that may be obtained through, provision of tax returns or any investigation that may occur about whether someone or some entity is paying the taxes that they're supposed to pay. And then finally, any home addresses and dates of birth. Remember earlier when we were talking about FERPA, I mentioned the confidential right to privacy as contained in the Pennsylvania State Constitution. Okay, well, this is in general a trend we have seen in response to the right to know law, where people were accessing home addresses and dates of birth. Okay, the courts have ruled that under the constitutional right to privacy, home addresses, for the most part, are considered private. Okay, you do not release home addresses. This could be employees, this could be the public per se. And then dates of birth, where we are is that the date is considered confidential, but the month and the year can be released if it's part of a record. Okay, and this is the courts recognizing concerns over identity theft. You do not release the date that a person was born. Questions popped up. Do you have to redact home addresses on building permits? No, and that's a great question, because the point of, well, the whole point of releasing the building permit would be moot if you don't list where the building is located. So here, what's come into play is what's legally known as the balancing test. And I don't want to get into the weeds here, but when the courts have ruled on the constitutional right to privacy, they've also said, unless there is, whether it's in the public interest to release the address. And if the public interest outweighs the right to privacy, that's your balancing test. So you would release it in the case of a building permit, because it wouldn't make sense. The building permit is useless if you don't know where the building is. Okay, that's a great question. What about Board of School Directors' home addresses? Again, Gene, that comes down to the public's right to know. You could conceivably withhold it through the right to know process. But if I want the home address of the school board director, I go to the election code. And when the school board director files their election papers, they have to give their home address, okay? And occasionally, if there's a dispute over residency, okay, there, the home address, it becomes in the public interest to know that the director is in fact a resident of the district. Okay, so it outweighs the right to privacy. So it's going to be case specific in your example, but it's a great example, and there is case law to support it, where you've got to perform this balancing test. And if there is a need to know, you would release it. But if not, you could withhold it. But like I said, there are other means for getting home addresses. I mean, in all honesty, if you Google my name, I think probably on about the 5th hit, my home address will come up. But, you know, we've got to look at what the law says. And I think you ask a very good question. Okay, do you have to redact home addresses on a request for the right to know log or even right to know requests themselves? Our recommendation is yes, you should do that. If on a right to know request, someone puts their home address and then you receive a right to know request for the right to know request, because it is a public record, what we recommend is that you redact the home address based on the constitutional right to privacy. Another good question. You guys have woken up here at the end here. This is great. Okay, and then it seems to me that the year of birth would be private because of age discrimination. It is not. The year of birth is considered part of a public record. And Monica, that comes down to like someone submitting a right to know request for employee records related to pension costs. Okay, by knowing the year of birth of an employee, you can get an idea of the calculations that go into the cost of pensions, public employee pensions and the like. So the year that, for instance, you know, I'm of retirement age, so that how can I put this? There is it's viewed as a public need to know. Within the public interest to be aware of how old I am in general. So that is considered part of a public record. It's just that the date I was born, the day I was born, is considered private for identity theft considerations. Maybe the law will change because this is an evolving area where the Supreme Court has kind of slowly, gradually leaned towards the privacy of public employees as well as public in general. It used to be that if you wanted, for instance, home addresses, if you wanted to see my home address, you could go to the state library and there would be a report on hand that had the home addresses of every state employee. Okay, that was pre-right to know. Now that you know, case law has evolved on this and the courts, well, it also has to do with technology. Having it out there on the internet, suddenly people woke up and said, wait a minute, this isn't right. And the courts agreed, okay, because it's a lot easier to look up a home address on the internet than it is to have to go to Harrisburg down to the education building, or in this case, the forum building, and look at that actual report, okay? A lot more work involved, okay? But now with you know, the internet, it's so much easier that the courts have said, okay, this is a valid concern, we're going to weigh in. All righty, going back to UCC, just to clarify, detailed house construction plans are not subject to open records, and we cannot give them out, even to the current homeowner. All right, I think I was speaking in generalities there. To the current homeowner, I believe that, well, no, I am sure that the confidentiality provisions allow you to give them to the current homeowner or to anyone who has a valid reason for needing them. For instance, let's say you've got a commercial dwelling or a commercial structure, and you've got a developer purchase that structure and they want to redevelop it, okay? Give it a facelift, reconstruct it for new use. All right, so they come to the borough and they ask for a copy of the legacy drawings because they want to see what's hidden underneath those drop ceilings and so forth before they start tearing things apart. the UCC allows someone with a valid need to obtain those plans and associated records, okay? I didn't go into detail on that when explaining it because of time constraints, but Katie, that's a great point to raise. Yeah, a homeowner should be able to see the plans for their own home, to answer your question, and the UCC allows that. All right, any other questions before we call it a day here? Like I said, you guys came to life here with some very good questions, and more than happy to answer them for you. Okay, well, if we log off here before you have a chance, or let's say, you know, something comes up, like I said at the beginning of the presentation, please reach out to our office. Give us a call or send us an email. The information's on the screen. Check out our website, okay? I've been referring to like the Final Determinations database. We have issued over 30,000 decisions in the life of the Office of Open Records, all of which are accessible through a searchable database. You can put in any random text string you want. You can put in your municipality, you can put in your name, you can put in, you know, for instance, UCC. In every decision that we have issued that relates to that text string will come up, and you can do your research and find out how we have ruled on specific issues. All right, but feel free to give us a call, send us an email if you've got a specific question or a specific problem, and we'll do our best to get you steered in the right direction. Okay, so I want to thank you for your participation today. I hope it was of use to you. Thank you for the kind words here. I'm going to sign off, but we're having another webinar in 2 weeks, and we look forward to seeing you then. Okay, have a great day, everybody.